rise. The Court of Appeals Division 1 is now in session.
Be seated. Good morning. Now is the time set for oral argument in cause number 1, CACV 130450, Flood Control District of Maricopa County versus ABC Sand and Rock Company. For your information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, you can critique your participation here today on YouTube in a couple of weeks. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left, and appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all of your time and not leaving you any. However, ultimately, your reserving of rebuttal time will be up to you. We have reviewed the briefs, we've conferenced the case, so we are well aware of the facts and issues attendant to this argument, and you might want to keep that in mind in addressing the court this morning. Counsel, when you come to the podium, I'd ask that you state your name and who you represent, and with that, you may begin.
My name is Sean Berberian on behalf of the appellant, ABC Sand and Rock. I also have the owner of ABC, Dave Waldmath, present in the courtroom. May it please the court. ABC Sand and Rock is a small family-owned business that began in 1985, built itself up from nothing. It is a highly praised business, highly rewarded business. Praised even from the Flood Control District on many occasions. The court, I would like to direct the court to three core issues for why the court should rule for ABC. First is that the Flood Control District cannot meet its burden to overturn the final decision of the review board. There's incredible deference given to a final decision of an agency. Second,
but there's only deference given when there's a reason to give deference, i.e. we can ascertain the basis for the decision. We don't give deference just because it says on a piece of paper we find X.
Correct, Your Honor. The deference we would, of course, look for is look for the basis of the decision. And in this case, we can find a basis of the decision in the record. Part of that deference is to uphold, unless there is no evidence in the record to support that final decision of the review board. And in this case...
Counsel, where are the transcripts?
Provided from the Superior Court?
From either the ALJ's hearing or a transcript of the proceedings before the review board. Where are those transcripts? I mean, normally when we get a record, we need... say if we defer to the record and we defer to the decision based upon the records that's provided, we don't have those transcripts. And you're the appellant.
Your Honor, it's my knowledge that the entire transcript was provided from the Superior Court, and the Board of Review provided its entire transcript to the Superior Court.
We don't have any transcripts.
Well, Your Honor, that's...
I'll take that back. Excuse me. We do have a transcript in the sense of the one-day meeting of the review board when they're discussing proceeding, and I think we may have a transcript of the argument from the Superior Court. But as far as the proceedings and the merits before the review hearing board and the ALJ, we don't have those.
I don't know where the error occurred, Your Honor, but we received notice that the Superior Court had provided its record to the Court of Appeals.
Did you go back and check the record to see if the transcripts were included?
I'm sure that I did.
Okay.
But because that's occurred, actually, I would request that because the court absolutely needs those transcripts as part of this proceeding, that we request the ability to then go back to the Superior Court and re-request them, that the court provide them to the Court of Appeals. Because the Court of Appeals absolutely needs the record in order to evaluate what evidence is in the record.
Were the transcripts from the review board hearing and the ALJ's hearings, were they provided to the Superior Court?
Yes, Your Honor.
Because I didn't see anything in its record when we looked at its record either.
That record was provided to the Superior Court. In fact, we went through a few steps between myself and opposing counsel for the Flood Control District and the Board of Review, wherein we had a discussion of what was going to be included in the record. And I received the confirmation copy from the Board of Review showing everything that was provided to the Superior Court. It's a thick record of, it was, I would guess, 8-10 inches thick of transcripts and other documents.
Point made that the transcripts were specifically included within what was said to be being sent up to the Court of Appeals? What I'm saying is, it's specifically delineated were those transcripts that you're saying, that we're saying we don't have.
Yeah, absolutely. The Superior Court has those transcripts, and the Superior Court sent the sheet confirming what that they submitted the record. Therefore, it is in the record. Therefore, it should have been provided to the Court of Appeals.
I will tell you that we've asked our clerk to check with the Superior Court clerk on those transcripts, and there's nothing.
Counsel, let's go ahead and proceed with your argument. Make your argument as best you can. Make it however you deem it appropriate. We may have to address this issue after the fact, but please make your argument so that you have time to argue what you want us to hear today.
Thank you, Your Honor, and absolutely, I will have to address that, what appears to be an error by the Superior Court. The three issues go to that burden of proof. Secondly, that the Flood Control District is stopped from denying the system of permit renewals that they created. And third, that the form of the decision by the review board was a procedurally proper order without findings of fact and conclusions of law, as those findings of fact and conclusions of law were not required by statute or regulation.
Well, let me get to that third issue. They may not have technically been required at the time, but as Judge Downey pointed out, generally we need something we can point to so we know what they decided. In this case, I have a hard time finding that the Superior Court somehow erred in saying, okay, I need to send this back down because I don't know what the basis for the decision was. So even if the board wasn't required to have findings, I mean, how can we say the trial court abused its discretion saying, I don't know what the basis for its determination was, and asked them to make findings?
Well, Your Honor, the Superior Court's position they were in was not unlike many court of appeals where they are confronted with a decision of a trial court where they issue a ruling for one party without explicit findings of fact and conclusions of law. And then the Court of Appeals is admittedly in a difficult position of then having to carry the burden of looking through the record. But that is the process that needs to be taken, is looking through the record to examine what evidence there is to support the ruling of the court.
So, go ahead.
Go ahead.
So the bottom line that you're saying is that, as in those situations otherwise where this happens in front of the Court of Appeals, we need to go back to the transcript. If we don't have a specific order reflecting what the conclusions of law and state issues of fact, conclusions of law and statements of fact, findings of fact, if we don't have that, we need to go to the transcript and glean from the transcript whether or not there was a basis such that the court did not abuse its discretion, correct?
That would be absolutely part of the steps to review the record. The transcript is a significant portion of that record.
Again, we're in a conundrum if we don't have the transcript and we don't have the findings of fact and conclusions of law.
And I can concede that. The conundrum that we're in, obviously, is created by the Superior Court failing to send the record, which was part of its record and confirmed to be part of its record. But
even, go ahead.
Well, moving past that a bit, ARS 12910E gives the Superior Court the specific ability to vacate and remand the agency action, and for all intents and purposes, we're treating the district as an agency because that's what Title 48 says. And the court can remand for further development when it appears from the state of the record of the administrative agency or otherwise that such action is just. So Judge McLennan had the statutory authority to remand irrespective of these other things we're talking about. And why would we say he abused his discretion in availing himself of a statutory remedy that's available to him?
Because the record has support for the decision, that final decision of the administrative agency. If there's evidence in that record in front of the Superior Court, that court doesn't need to send it down. Therefore, it's error to send it down.
What stands for that proposition? When the statute says he can vacate and remand, and he can do it as it appears that such action is just, what authority is there for the proposition that he can't do it?
Well, it would be the general principle of the rule in 12-910, which states that Superior Court must affirm unless it finds there is no substantial evidence in the record or arbitrary and capricious.
So then we can assume that he didn't find that if, in fact, he did remand.
You could. The other thing that I guess, if the trial court, excuse me, the Superior Court, which was sitting in an appellate position, if that court felt that additional facts needed to be developed, the Superior Court could have issued or ordered a trial de novo and actually collected evidence so that we wouldn't be in this position. If it's an issue of evidence to be collected, under the Act, the court had the authority to do that, but the court didn't do that.
Okay, so you're suggesting that the trial court should have set a hearing, brought the board in, and had them testify as to what the foundation of their decision was, as opposed to remanding for findings of fact and conclusions of law?
Theoretically, or the court could have, in a trial de novo, obviously requested, Superior Court could have requested other testimony be issued, even the similar testimony that was given in front of the flood control district, in front of the hearing officer there.
Did you ask for a trial de novo?
Absolutely not, Your Honor. We didn't feel that a trial de novo was necessary because there was a
So you're saying the court should have sua sponte ordered a trial de novo if it felt that sufficient facts weren't available to it?
Theoretically, it could. Either party could have requested it. If the flood control district felt that additional facts needed to be developed, it could have requested it. But we believe that the final decision of the review board was proper and supported by the evidence in front of the agency.
But isn't there a practical problem here in the sense that the trial judge, there's this administrative law judge's recommendation, then the CE's decision, which has a number of different factors to it. And there's the fine, and there's the issue of cooperation on trying to get the permit, a longer permit issued. And then the board just says, we revoke the order. And we don't know what the trial judge doesn't know, does it saying, well, gee, the fine isn't appropriate, or that they don't need a permit at all, or they don't need to continue to cooperate on getting a new permit? Isn't that a sort of the reason why we should affirm the trial court? Because we just don't know, the trial court didn't know, and we don't know what troubled the board about the chief engineer's order.
That's a fair question, Your Honor. What actually I think we need to look at is what actual issue what charge was issued by the flood control district. There was one charge here, operating without a permit. There weren't numerous charges. I liken this to a jury verdict where you have a charge and the jury rules for the plaintiff or the defendant. In this case, they ruled for ABC. There's nothing ambiguous about that because we only had one charge. Did you operate without a permit? Now, if the court rules, or the board rules, it did not operate without a permit, the logical conclusion from that is that ABC's permit was in fact renewed. And then we get into the question of what evidence supports it. But
renewed on what basis? You can see the confusion. I think if I'm correct, there's sort of flinging back and forth of new letters, where I guess your client says, okay, the CE's decision has been revoked, return my $6,400 and issue me a permanent permit. I don't have to do anything else. And the district then takes its appeal to the Superior Court. Because, what is this district supposed to mean? Does it mean that they can operate without, just by submitting on the submission that's already, the material's already submitted? Or does it mean that the fine has just been revoked? Or what, it seems to me findings of fact and conclusions of law would be the benefit of both your client and the district, as they would know how to proceed from there.
In an ideal world, absolutely findings of fact and conclusions of law are helpful for a court of appeals. there's a couple things I'm very concerned with, which is if the court were to remand to that Board of Review, I'm very concerned about a different decision coming out of that Board of Review. And I know a lot of that is outside the scope of the record here, but that is a major concern. We feel that the decision was made and that we shouldn't allow them the opportunity to allow undue influence to change that decision, because
Okay.
I feel like this is going to be back up in front of this court.
So what you're saying is that if this was remanded by the trial court back to the board, and they had to make findings of fact and conclusions of law to support their position, they may not be able to do that and would have to reverse themselves?
No, what I would suggest that, and of course we're speculating here, I would suggest that we might get an inconsistent order with some sort of change of decision because of undue influence by other people within the flood control district who wanted this appeal.
You are speculating. Is there any other reason why a remand so that both parties could determine what the board intended shouldn't be done? Was it an abuse of discretion?
Because we believe that under the statute, and that the court must give deference to the decision made, is that there was a final decision made by that board, and there's a record to support that decision.
But the other problem that I see with that argument is, as you know, we review legal conclusions de novo, and we don't know whether they made legal conclusions. I'm looking at the hearing review board minutes, and your predecessor, Mr. Lesotho, argued a lot of legal issues, saying that there was an illegal demand made by the district upon your client, that they were permitted by a course of dealing. I mean, there were a lot of issues that could have raised questions of law that we would review de novo, but we have no idea what the basis for the decision was. Was it something factual that we give deference to if there was evidence in the record to support it? Was it a legal conclusion? I just don't see how we can, by looking at the transcript, know the answer to any of that.
And again, I go back to the analogy to a trial court decision where you can have a trial court make a decision or rule for one side without giving the explanation, but there's a record which can be then examined after the fact to find if there's something to support the ultimate ruling. If we don't have something that shows actual error, we don't presume error. We don't search for error. The principles of law we follow are, we presume that the decision was proper and had a proper foundation by looking through the record to see if something supports the decision. And again, I appreciate the difficulty an appellate court is put in to try to dissect the record, but the statutes and regulations are drafted the way they were, and the regulations are drafted by the board of directors the way they were. In fact, 2 weeks before the hearing in March, the board of directors issued the regulations setting out what that final decision would look like and the procedures that the review board would use. And they were very specific on how they would issue that decision. Now, after this occurred, the state, based on lobbying by the flood control district, they changed that law in an effective, after this hearing in May of 2013, findings of fact and conclusions of law were thereafter required. And the decision was thereafter required to be in writing, but at the time in question, those requirements weren't present. Therefore,
But they certainly weren't something that couldn't occur in the absence of the allowance under statute. The court had the right to request the findings of fact and conclusions of law.
I believe the Superior Court has that right if it gets over the first hurdle, which if it cannot find that there's if there's evidence in the record to support it, I think they can remand it. But I think that's where we are in the mistake of the Superior Court, is that it didn't give the proper deference to look at the record and say, okay, I can find these pieces of evidence to support it. And again, it's not a preponderance of the evidence that the Superior Court or the Court of Appeals looks at it. It's not fresh eyes in that manner. It's, can I find any evidence in the record to support this decision for ABC? And the answer to that is yes.
But that also presumes that we would then have to go through all of Mr. Lasorda's arguments and say, these are the issues, the legal issues that I'm presenting to the board. And we'd have to presume the board ruled in his favor on all of those points, even if those were erroneous as a matter of law. Now the Superior Court would have to do that too.
Quite possibly, Your Honor, if the Flood Control District argued some issue was in violation of law and that there's nothing in the record to support ABC's prevailing on that issue, that would be on their burden to demonstrate that.
But the Superior Court and we would review that de novo. And if they were wrong as a matter of law, no matter what the facts were, assuming the facts supported, I mean, if it misapplied the law, it's still erroneous. And we'd have to go through all of those and figure out, gee, did the board reach that? Did the board reach the issue about whether they already had a permit from course and dealing? Did it reach a determination as to why the fine wasn't appropriate? Whether there was authority to issue a fine? We have no idea, and the Superior Court had no idea of any of those, and some of those may be legally wrong. A matter of law.
It's a fair point that it's difficult, but I would say it's not impossible to do, and it's the difficult position that appellate courts are put in. I feel for the court for having to do that, but to impose that duty and send it back down and go through the process again when the duty wasn't required is the problem that we have with that. And just turning to the second issue, which is that the flood control district had created a renewal system here where the licensees who have permits didn't have to go through great lengths to renew that permit. They were very simple, summarily approved permit renewals. It was an automatic system. When we look at the record, it began in 2001, for example. We have decades of record with ABC. Or in 2001 renewal, ABC submitted a permit fee a renewal fee to the flood control district and a one-page renewal form and nothing else. There were no other steps required from them to renew, and the flood control district renewed. The only thing that they issued was not until 14 months later that they actually issued any kind of signed document showing there was a renewal. And then in the next renewal period in 2006, flood control district didn't issue anything, in fact, in that renewal. The flood control district and didn't require ABC to do anything except for pay a renewal fee again. And in that case, there was a documentation of a handwritten note showing that there was a new due date or expiration date in 2011. Again, there was no formal documentation issued by the flood control district. This is not like the DMV where they issue a formal license to you like they should. It's a very informal system. And then in 2011, ABC followed the same system where we submitted a permit fee and submitted a one-page application, and then we were inspected in March 2003, and the inspectors approved all of their examination of ABC's operations, finding it was per plan.
Counsel, you're out of time. In fact, I'd let you go a bit longer because I knew I wanted to have you finish that argument.
Okay, thank you, Your Honor.
Thank you.
Please, the court, Steve Tully, on behalf of the Maricopa County Flood Control District, the appellee in this matter. Well, you know, there's a lot of arguments in the appeal. Some of them weren't addressed, and if the court wishes me to address the ones that weren't brought up in the argument, I'm prepared to do so. I want to address sort of the three items that were just mentioned by counsel. The first one is this claim that somehow the court doesn't have the authority to remand the matter. And I think the court has correctly addressed that issue. It certainly does. The statutes provide that the court has remanded it. So the idea that somehow the court needed to find for ABC and didn't have the power to remand is simply not supported by the law and not supported by the facts.
Counsel, is it within the discretion of the court, even where there may be a transcript that has abundant amounts of support for the position, to kind of require the board to do the heavy lifting and take that record and consolidate it down to an order that the court can then pass on? Is that acceptable?
I think so. I mean, the statute provides the Superior Court with the authority, if it needs it, to remand the matter to the tribunal for for any action that it deems just. Now, of course, this court could review it on an abuse of discretion basis if there were some, crazy situation where there was a very lengthy determination of facts, and the person seemed to be, I don't know, gaming the Superior Court judge, gaming the system or something, or trying to delay something by sending it back. But I mean, that would be a rather crazy fact situation. I mean, in this case, there clearly is not. There's nothing there for the court to weigh whether the board acted arbitrarily or capriciously, whether they followed the law correctly. In fact, if the position taken by ABC is correct, then they clearly didn't act according to the law. I mean, this idea that somehow the board, that the flood control district can, by not following the rule, the Arizona statutes, and by not following regulations, can therefore obviate the need for anyone to comply with them in the future, is not supported by any law, and it's a rather absurd concept. I mean, in this case, they've admitted that the inspector that was previously inspecting ABC, who retired, was lethargic. That's a word that they use in their brief, was lethargic, and didn't follow the rules. Well, he retires. They get someone in ABC who understands that the law requires that the regulations be not ABC, rather at the flood control district. Get somebody in who understands that the regulations are needed to be complied with. They notify ABC that he needs to comply with them. They notify him ahead of time, plenty of time to comply with them. And ABC says, I'm not complying with them. I mean, that's the record in this case. And they're saying, well, somehow he's a stop. That's one of the another arguments they make, that the district is stopped from enforcing its regulations. Well, there's no, it's an absurd concept. So, I mean, if the court, the Superior Court, I think clearly, if it were to accept that was the only issue presented by ABC, presented to the board, would have been, should have ruled in favor of the flood control district and overturned the advisory board, but it didn't do that. It noted that there was a lot of issues up in front of the advisory board, like the fine, like other things, and therefore properly sent it back. I'm sorry, Your Honor, it looked like you want to ask me a question.
So am I understanding your argument in part to be that even if we had a transcript, it doesn't really change the result because the trial court had discretion that it properly exercised in returning it to the board for findings of fact and conclusions of law to assist it in determining whether there was any error?
Yes, Your Honor.
Okay.
Now, and I don't know if the court's interested in these arguments or not. I mean, the appeal argues that that the appeal was not timely. I mean, there was an order in this case, and the facts are undisputed that there was an order, and it was timely appealed. The arguments in the briefs argue that, well, the court should ignore that, the court below should have ignored that, and this court should ignore the actual order that was issued and consider the order as being issued when it was verbalized at the hearing. And I think the arguments are in there. It's simply not how we do it, as I'm aware of. In any court in Arizona or this country, might have worked in ancient Greece, but we don't verbally issue orders. There needs to be a writing so we know what was in the order. So we think that argument has no basis. There's a claim that the minutes should be considered the order, and again, those are minutes. Those are not an order. There is an order, and there's no showing that somehow that was procured by fraud. It's not unusual for courts or any tribunals to delay issuing a formal order, and it's not unusual for attorneys and parties to call courts and say, hey, is that order coming up, or JA or somebody, and say, when are we going to get that order? We need to run the appeal, and that's what occurred in this case. It's not unusual, and the court below found that was that the order was properly issued and timely. The appeal was timely, and so the appeal on that issue we think is without merit. It was a claim that the flood control district and the board are the same entities. They're not. They're two separate entities. The board itself, actually, the district itself, actually is not subject to the Administrative Review Act. It's a county entity. The statute that allows them to be part of that allows review specifically mentions that the Flood Review Board is subject to the Administrative Review Act, not the county. And so the notice is that they're two separate entities, and so the flood control district is not appealing itself any more than an agency that appeals an administrative law judge's ruling would be appealing itself. Does the Superior Court, they ask whether the Superior Court has the authority to review this. We've talked about that. Yes, they do under the statutes. They have the ability to remand it under 12-124, under the, actually, as well as under the Administrative Review Act.
Going back to your earlier argument, it's kind of an academic point, but it interests me because it seems to me that the statute you mentioned, 483615.02, which says the final decision of the Board of Hearing Review is subject to judicial review under Title 12. And it's kind of shoehorning this odd entity into an agency rubric. And in the Administrative Review Act under Title 12, you never would have the agency as the appellant because it's the final agency decision that's at issue. And so it is somewhat anomalous to then try to shoehorn the Board of Hearing Review into the role of agency. It's not an exact fit. And while at first I thought the argument that you couldn't appeal because you're the same entity was kind of a lightweight argument, I get that argument, and I see on an academic level how it arises because there's not a perfect fit between these entities and agencies. Do you understand what I'm?
I do, and I agree with Your Honor that it was these things happen. It's not a perfect fit, but if you look at the definition of agency under the Administrative Review Act, under 12-901, it says that agency means an agency also means a administrative review board. It means so the board comes within the definition of an agency under that act, specifically under that act, under 901. And in fact,
it does, but doing these administrative appeals for 4.5 years in the Superior Court, I cannot think of another entity where the final decision is not that of the agency. This is probably the first one I've ever seen that has, obviously your client could not appeal the chief engineer's decision because that's the district. And in virtually every administrative agency context, that would be the final decision that's subject to appeal. But then by statute, we've got this hearing review board, which takes it out of the normal context.
How do we distinguish the board from the district?
Well, the board is, it's appointed separately from it's appointed by the county, and it has duties that are separately delineated both by statute as we've gone over in this statute to be the final review board. So it's a separate entity in terms of that. I mean, at some point I think we could argue that the Superior Court's a part of the county. So is that part of the same? It's a subdivision of the state. As this court is a subdivision of the state. They're all just layers of subdivisions of the state, but we recognize that some are different entities than others. In this case, it may be a unique situation because the statute, creates this board under the Flood Control District, and then specifically directs that the Flood Control District Advisory Board is subject to this Administrative Review Act, and so it's a separate situation there. But I think that's evidence that there was intent to treat it as a separate entity because you can appeal its decisions.
You agree that your client couldn't appeal the chief engineer's decision?
Correct, right, and nor could the appellant in this case, except to the board. And so,
But from our standpoint, we know that both the district and ABC appeared before the Board of Hearing Review and as parties.
Correct.
And on some basis, ABC won before the board.
Correct.
Okay.
Which shows they're not the same entity. Otherwise, I mean, it becomes, if they're, they'd be arguing among themselves to an extent. I mean, the ABC appeals it. They had a hearing instead of this appeal board, they could have had just a separate ALJ review it, but they have the review board. But there was a proceeding with rules, and they presented their evidence, and I think the clearest evidence they're not the same entity is that they came up with a different response, right?
And the district was represented by counsel before the hearing review board. Was Ms. Livesay the counsel for the district at the time? I'm looking at
There
the
was.
minutes.
It's my understanding, and I wasn't representing the county, that the flood control district at that time, that the board has had separate counsel from the district throughout the entire proceedings, and the board has separate counsel. So it's treated as I think the evidence clearly that it's treated as a separate organization. Sure, they're dealing with the same subject matter, but that doesn't make them the same entity.
Sounds something to me like at least there's a lack of an exact fit with the APA, the Administrative Procedures Act, but that's something for the legislature to parse out.
I agree, Your Honor. And so I think the result in this case, I think that the lower court, has come to I think a fair conclusion. It hasn't ruled against the appellant in this case yet. He's only referred it back for remand. I understand they may be concerned that they're not going to get the result that they think they have received, but maybe they will, maybe they won't. And then that issue, then they can appeal that and make some of these arguments, I suppose, at that time.
Or you could appeal that.
Or yes, correct. The district could appeal it.
On the issue of transcripts, do you have the same recollection as Mr. Berberian that those were before the Superior Court, the transcript of the hearing before the hearing officer, Mr. Murkow?
Your Honor, I did not appear before that was the court. I took this over just after it was sent on appeal. But I have the file. I could look at it afterwards and see if it's in there. But
Again, your argument is, regardless of the transcripts, there wouldn't be an abuse of discretion to send it back down simply to clarify what the board wanted to do. Is that right?
Correct, Your Honor. And I don't think that not only that, but I think the notion of coming up with of forcing the Superior Court to come up with a decision tree of all the issues and the legal arguments on both sides and trying to determine which legal argument was accepted, because sometimes there's more than one. For instance, in this appeal, there's multiple issues that they've argued, and if the court were just to issue an order, we wouldn't know which of the 6 or 7 arguments they made. So I don't think the Superior Court could do that. I think there's plenty of case law where the appellate courts have said have overturned decisions and said I can't determine the issue. Are there instances where the courts, appellate courts, have reviewed the record and said I can determine the basis of a decision? Yes, I think there are. But are there cases where appellate courts have said the opposite? Certainly. And in this case, with the multiple issues, I think it's that type of case. And certainly, the Superior Court isn't required to perform some type of lengthy analysis and see if it can possibly come up with decisions with reasons why he thinks the board came to a decision it came to. So I think that he's entirely within its discretion to send it back to the board. Makes perfect sense. Clean up this thing.
In a sense, the Superior Court could come to a conclusion that what the board meant to do was to say that ABC Sand could continue to operate simply by paying $15 or $20, not even paying $6,400, with a one-page application or a letter, and the board might say, well, that's not what we meant at all. We just don't know. Is that right?
Yes.
Anything further, counsel? All right. Oral argument is concluded at this time. Gentlemen, thank you very much for your argument. It has been helpful to us today. We are under advisement, and the ruling will issue in due course. Thank you.